Council's webinar on the Legal Ombudsman's new scheme rules. I'm Sarah Richardson, the Head of Ethics and Regulation at the Bar Council. I wanted to briefly give you some context to the new rules. The Bar Council's Regulation Review Working Group responded about a year ago to an Ombudsman consultation on their proposed changes. We were broadly supportive of the proposals as they aim to create a more proportionate set of rules that would lead to a more efficient complaints handling process to the benefit of both legal services providers and consumers. The new rules came into effect this April. The most significant change sees a reduction in the time limits for clients to bring complaints to the Ombudsman. Previously, a complaint had to be brought within 6 years from the act or omission, or within 3 years of a client realizing that there was a concern. That has now changed to 1 year and 1 year respectively. This will require chambers to update their complaints handling policies and client care letters. I'm now going to hand you over to Jason Chapman, our speaker for this evening. Jason has been in his current role as Legal Ombudsman with the Legal Ombudsman for 10 years, already having cut his teeth as an investigator for them. He's got a wealth of experience and knowledge, and he's going to guide you through the changes to the scheme rules. And at the end, if you have any questions, you can ask them using the Q&A function. We're grateful to him for taking the time to explain the new rules to you this evening. A small piece of housekeeping. Please be aware that we're recording the webinar. Thank you, Jason.
Thank you, Sarah. Thank you for the introduction. Thank you for the Bar Council as well for allowing me the opportunity to speak today. And thank you for everyone listening for taking your valuable time to hear what I've got to say. I'm going to share my screen now because I've got a short presentation to share with you. So bear with me while I do that. Hopefully you can all see that now. As Sarah said, I'm going to go through the scheme rule changes that we're implementing. I'm going to give you a bit of background and context as to why we're making the changes and then go on to the changes that we're making. So our scheme rules have changed. There's 4 main areas of change. And what I'll do is I'll go through them individually and provide the background to them and what we are changing. What I do want to say, as Sarah said, that the changes came into effect on the 1st of April 2023, but what we're not doing is we're not applying those changes retrospectively. So any complaints that were with us up until or received by us up until the 1st of April 2023 are on our own rules, old rules. So we are dual running old rules and new rules for a period until such time that the complaints that we're dealing with that were received before the 1st of April 2023 have been resolved and closed. So we're going to be going through this period for probably about 8 months to a year where we are going to be sort of dual running both sets of rules. And what that means effectively is we've had to make the changes to our systems and processes to be able to accommodate that. So just to provide you the context, like I say, some background, why have we changed? Well, what were the current scheme rules up until the 1st of April 2023 have been in place pretty much unchanged from the date we opened our doors on the 6th of September 2010. There have been minor revisions during that period. For example, in 2012, we made 2 changes to our scheme rules, which were to change the time limits and also to allow ourselves discretion to investigate complaints where there'd been an unfair refusal of service. But by and large, the scheme rules that we have been running with up until 1st of April 2023 are the original set of scheme rules. So from that period, from 2012 to 2022, when we've started to consider what we wanted to do to change the scheme rules and what we wanted to do really at that point in 2022 when we started looking at this as a project was sort of used the previous 10 years of experience that we'd had running the scheme to determine where the scheme rules didn't allow us to run the scheme as efficiently and effectively as we could do, and we wanted to use that experience to ensure that we were only investigating complaints that we could fairly investigate and determine. So we went through the review period, which led to the consultation that Sarah mentioned, which went live in April 2022. And in fact, what we wanted to do is we wanted to do a review in 2 stages. Firstly, we wanted to implement and effect changes that were within our gift to make, so the changes to the scheme rules that we could make ourselves. But secondly, and there is going to be a stage 2 of the scheme rule review, that's going to be changes that we need external support in effecting those changes. For example, changes to our case fee regime would require Lord Chancellor approval. So we would be going out to him or her to seek approval for those changes, and changes where there's requirement to change to primary legislation. So there'll be a change required to the Legal Services Act 2007 that will require support of our oversight regulator, the Legal Services Board, and we're going to be making recommendation for changes that will require legislative change, and that will be happening sort of the end of this year, beginning of next. And the change, for example, to the Legal Services Act, at the moment we can't outsource ombudsman work to non-ombudsman at times of peak demand, which we may wish to do if we weren't able to deal with workload demands at any particular time. Obviously, going through the pandemic, like as with a lot of ombudsman schemes, we had a peak in demand at the time where we were challenged with regard to resource, and we've ended up with a large backlog that we're having to work through now to resolve. So it would help us in the future to be able to outsource work to appropriate organisations. So, but that's, like I say, that's going to be consulted on perhaps end of this year, beginning of next, but we're currently sort of deciding what we want to do with that. But what we were able to do is, like I say, make the changes to the four main areas that I'll go through today with you. They were, like I said, consulted on in April 2022. The consultation ran for 8 weeks. We did get a great deal of response, but obviously Bar Council, the other regulators, consumer groups, and what was surprised us was, even though where the changes are arguably, potentially to the detriment of some clients, for complainants, for example, with the time limit changes, everybody was broadly supportive of them for the reasons that we propose. And what we want to do is make sure that we're running the scheme as efficiently and effectively as we can, and that is to the benefit of everybody who deals with us, both on the complainant side and on the service provider side. So following the consultation, we sought approval from our own board and then the Legal Services Board, who approved the changes in July 2022. And from that point to the 1st of April, it seems a long time, but because of the changes were quite sort of wide ranging in terms of our own business, we had to go through and make the relevant changes to our systems, processes, guidance, websites, and communicate them out. So it was a long process that involved sort of quite a detailed amount of work and a large project team, which is why we were only able to really go live with the changes on the 1st of April 2023. So, as Sarah said, the main change to the scheme rules at this point is the time limit change. And Sarah set out what the previous time limits were. What we actually started with in September 2010 was 1 year from act or omission, or if it was more than a year from the act or omission, you had to become aware of it in the previous year. We changed that in 2012. That was one of the main change that we enacted at that time, which was the change to you can complain within 6 years of the act or omission being complained about, or if the act or omission happened more than 6 years ago, you had to become aware of it in the previous 3 years. It's important to say that an out-of-time complaint is not out of jurisdiction for us. We do have discretion to allow a complaint that it is outside those time limits. And the discretion test we've had up to now was always where there's exceptional circumstances. So it was a high bar. We were looking for sort of, and in fact, what that effectively meant is we didn't really investigate out-of-time complaints. What we're doing now, what we did in 2023, is we've gone back to our original time limits that we started with in 2010, which is 1 year from act or omission. Or if the act or omission was more than a year ago, you had to become aware of it in the previous year. And what we want to do is it's not exclude complaints, for example, where there's a conveyancing matter where somebody bought a property 10 years ago, but they only became aware of the issue with a purchase upon sale. We've always investigated those. But what we found with the older complaints, the sort of stuff that was sort of 5-6 years ago, it was a problem for us in investigating them, and the reasons for that were fairly obvious. The people who dealt with the matter may not have been there, the firms might have closed, and there's issues with obtaining the evidence, either from the complainants themselves who hadn't retained it, or from firms who destroyed files under their own document retention policy, which caused us problems in investigating complaints. So what we wanted to do is really sort of concentrate our investigations on stuff that was fresher, where the people were still around, where the evidence was still there, and the complainants had retained information and evidence to support their complaint. There was a secondary rule, a time limit rule, which is set out on this slide, which has not changed and will not change, is that even irrespective of the 1 and 1 year or 6 and 3, the complainant still needs to bring their complaint to us within 6 months of the final complaint response from the service provider. What we do require is the service provider to provide relevant and correct signposting information to us, so the complainant is aware that that's the end of the first tier complaints process. But if they remain dissatisfied, they can bring their complaint to the legal ombudsman, and this is the address and details to do that. And then from that point, the complainant has 6 months to bring their complaint to the legal ombudsman, and we can accept it for investigation. That 6 months time limit has not changed. But what has changed is because we are mindful of the fact that we are closing the door to a number of complaints. The research that we did prior to the consultation was that 30% going forward, 30% of cases that we previously accepted on the 6 and 3 would be out of time on the 1 and 1 year. We've changed the level of the discretion test from exceptional circumstances, and going forward it will be brought in line with our general decision making discretion, which is set out in our Scheme Rule 536, which is the ombudsman decides what's fair and reasonable in all the circumstances. So that's the test that going forward we're going to be applying to our time limits. If it's out of time but it's fair and reasonable to allow it in, we will be letting it in. And the reality of that is that we will going forward be investigating more out of time complaints. What does that discretion mean? Effectively, what we're going to be looking at is reasons why it's fair that the complaint hasn't been brought to us in time, and it'd be fair to look at them. I think in the first instance, a lot of this will revolve around what the complainant's understanding is of our scheme rules and what they've been told. There's going to be a lot of complainants coming through first tier at a point where we're changing our scheme rules, who will have been told about our 6-year and 3-year time limits, which would have been completely correct at the time, because that's what the time limits applied when they went through the first tier. And we will see complaints coming through to us that are out of time, and complainants will say, yes, but I was told that I had 6 years to bring the complaint, or 3 years from date of awareness. And if they can show evidence that their final complaint response says that, or their client care letter says that, or any sort of correspondence they have with their service provider, chances are we will probably let that in. Similarly, what we're going to be looking at in terms of, aside from that, and that's going to be, I think, the main reason we're going to allow stuff in discretion for the first few months following the changes. But going forward after that, we're going to be looking at reasons why it's fair to allow it in, and it might be around issues like the client being vulnerable, or what, these kind of sort of reasonable adjustment issues where it might be fair and reasonable to allow those in. But what we've done is we thought very carefully about and we've put why we would let in an out of time complaint, and we've put sort of criteria and categories around this, and we've trained our people very in a great deal of detail as to how and when we're going to apply this discretion. But like I say, 6 months rule from date of final response still applies, but the discretion test has effectively dropped from exceptional circumstances to what's fair and reasonable in all the circumstances. So that's the time limit rule. That is, I think, from our point of view, that was the major change, because that's going to affect the number of complaints that come through to us. Like I say, the rationale being very much we want to be investigating the fresher, newer complaints, and that enable us to effect an effective investigation. Because under the Legal Services Act, we're required to undertake investigations quickly and with minimal formality. And really, an old complaint where we're having difficulty getting the evidence doesn't really support that. So that's rule 5 points, right, this time limits rule. And like I say, we will be dual running new and old for a while. The second change that we're making is to rule 5.7. So current rule, scheme rule 5.7 allows the ombudsman discretion to dismiss or discontinue a complaint where there's a compelling reason to do so. And the rule sets out a number of circumstances where we may wish to apply this discretion. We haven't given ourselves any new powers from the 1st of April 2023, because we've always had the discretion to dismiss a complaint where there's a compelling reason to do so. But what we've done is we've added in a few new rules of what constitutes a compelling reason. So there's some changes in terms of new rules and changes to additional rules. So I'll go through each of them in turn. So the new rule is a test of proportionality and a de minimis test in 5.7b, and that would apply where the alleged level of detriment is so minor that it wouldn't be appropriate and reasonable use of our time putting the case through an investigation process to an ombudsman's decision. And a real example of that was a case we had that went all the way through to ombudsman decision a few years ago that I dealt with and I had to deal with. And the complaint was from it was local to us in Birmingham. A local businessman wanted to enter into a supply arrangement with a local supplier. Local supplier gave him a supply of goods and services agreement, and he wanted a solicitor to look through that and highlight any onerous clauses, any reasons why he shouldn't sign it. So a local firm agreed to see him. They saw him at short notice. They took him into a room, turned the pages, and said that there wasn't any onerous clause in there, so he signed it. It was a couple of hours work at an agreed fixed rate that he paid. But then he raised a complaint, and the complaint was that the firm had failed to empty the litter bin in the meeting room. The complainant referred to rotting apple cores and rubbish. And the reason that he complained was he found that disrespectful to him as a local businessman, and he wanted an apology from the firm for that. The firm's view was they accommodated him at a short notice. They didn't think they'd done anything wrong. They gave him the service that he wanted, and so they refused to give the apology, and that went all the way through to an ombudsman's decision. It's not an appropriate use of our resource to investigate that kind of complaint. And although that's a fairly extreme version, we do see a lot of complaints like this that we think, really, is it an appropriate use of our time to potentially take all the way through into the investigation and then to an ombudsman decision? And it's not. So we're looking to allow ourselves discretion, be clear that going forward that we are not going to be investigating these cases. At the other end of the spectrum is a new rule 5.7p, which is again a proportionality rule, and that's the other end. Like I said, that's the other end of the spectrum. That's where a matter is so complex, there's so many complaints, or the amount of evidence is so large. For example, bundles of 10,000 plus pages of evidence have been received, that it's again not an appropriate use of our resource. And as I said, the Legal Services Act says that our investigation should be undertaken quickly and minimum formality. And this rule is intended to apply where the size of the complaint effectively prevents us doing this. What we don't want to do is sort of dismiss all the big stuff. We can and do look at large complaints on a daily basis and complex matters as well, but there might be stuff that's so large and complex and will take so much time that really we're not best placed to deal with it. And so we would choose not to. And we'd also want to apply this rule going forward in a way that we haven't done before, where the behaviour of the complainant is such that it's effectively preventing us from undertaking an effective investigation, where we get, for example, very difficult, challenging complainants who try and frustrate our scheme, refuse to allow us to progress the investigation. We receive multiple contacts from them a day, either via telephone or email, and basically what it means is that the investigator who's looking at the matter ends up spending a disproportionate amount of time on that one complainant to the detriment of all their other cases. What I would say with this is this will be applied on a very rare basis, but we have had cases in the past where we would have applied it had we had the discretion set out in the scheme rules to do so. And it forms part of our unreasonable behaviour policy that we have with our stakeholders. And anybody who gets a case dismissed for this reason, it won't be a surprise to them, because they would have been given warnings and the option and the ability to moderate their behaviour before we took such a step. But going forward, we want to have the discretion to do so. And finally, the final change that we're making is a new rule of where there is undue delay. And what we found is that we've had complainants that bring complaints to us where they've raised a number of issues with the firm, but only want to take forward a few complaints to our investigation. But when we're investigating a complaint and they find that it's not really going their way, they're not getting the service finding that they wanted, because we find nothing wrong or little wrong, they try and draw those complaints in at a later stage, which isn't really fair on the service provider, because it elongates and frustrates the process. So if what we want to do is, although these complaints are technically within our jurisdiction because they've been raised at first tier, if a complaint is then the complainant doesn't want to take them forward at second tier, but then part way into the investigation wants to draw them back in, we don't want the discretion to say we're not going to do that. So we're dismissing complaint where the complaint's brought subsequent complaint issue to an ongoing investigation that they should reasonably have known about at the time that the investigation was accepted. And a lot of the time, like I say, they know about it, we ask them about it, and at that point they choose not to do so. So we want the discretion to be able to say, no, we're not going to investigate those complaints. So although they're in our jurisdiction, we would dismiss them. In addition to the new rules, we've made a couple of changes to existing rules as well. 5.7a says that we will dismiss a complaint where there's no prospects of reasonable prospects of success, or the complaint is frivolous or vexatious. We've stripped out frivolous and vexatious from that and to make it form its own separate rule. And the reason that we've done that is the vast majority of cases that we dismiss under 5.7a are for reasons where we can't reach fair determination of the complaint. It's not that they're frivolous or vexatious, but because we've drawn the two into the same rule, we have to explain it, and it generally tends to cause upset with the complainants who think that their complaint is being dismissed for that reason. So we then have to explain that it's not that, it's just not, it's frivolous or vexatious, rather than there's no reasonable prospects of us fairly determining the complaint. So that's been stripped out. Like I said, we will on rare occasions dismiss complaints where it is frivolous or vexatious, but like I said, we don't want to sort of muddy the waters with 5.7a. We just want to have that where we can't come to a fair determination of the complaint. And the other change that we're making to an existing rule is 5.7c, where prior to the 1st of April, that was where it was a reasonable offer made and open for acceptance. But what we want to do is draw in offers that have already been made and accepted as well. We have been dismissing those, but we've dismissing them as a compelling reason. But we want to draw that into Rule 5.7c because, like I say, we do get a lot of cases where the first tier offer's been made, it's reasonable, and it has already been accepted, but then the complainant comes to us anyway wanting an investigation, and they've had the reasonable offer, and it's fair to say to them, look, you've had the offer, you've accepted it, so we're not going to investigate it. So we've sort of drawn that in. What we have done, what the rule does say, is that the offer accepted has to be reasonable. So if we felt that the offer accepted wasn't reasonable, we don't have to dismiss the complaint, and we wouldn't do so anyway. So that's just a change to Rule 5.7c. In addition to the Rule 5.7 changes, what we've also done is we've introduced a new rule that allows us to close cases if it's fair and appropriate to do so following the investigator's case decision if there's no substantive reason by either party for that rejection. And the reason that for this is to reduce the demand for final ombudsman decision, and it says empower the investigators in their work. We've always had the discretion to close a complaint following a case decision if there's no response from the complainant, and we do that under our Scheme Rule 520. We always have done, but going forward, what we want to do is extend that out. So if there's no material reason or substantive reasons, if it's not based on evidence or as there's a disagreement with the facts set out in the case decision, we may wish to choose to close the complaint as being resolved by the case decision. As I said, our investigators, the work that they do, the reports that they produce, we do have a high level of confidence in, and that's borne out by the number of final decisions that the ombudsman makes that basically endorse the case decision. If an ombudsman doesn't agree with a case decision, they've got discretion to issue a provisional decision to change the investigator's view prior to making a final decision. But that's only done in approximately 5% of all cases. So 95% of the time, the ombudsman is endorsing the findings of the investigator. And actually, of that 5% where it's not endorsed, the vast majority of those cases, The reason that the Ombudsman's changed their view is due to evidence received after or comments received after the case decision. So what we want to do effectively is, like, going forward is, and again, we've set out criteria for this. If the case decision, if the case is closed under Scheme Rule 520, if the case decision does not recommend a remedy, first that any further action is needed. However, if the case decision recommends a remedy, we would expect the service provider to honour this. That's the change, really. To an extent, we've always done that, but like I say, if we choose to dismiss a case under the new scheme rule, in some cases there will be a poor service finding. There will be a remedy recommended. If that is the case, like I say, we'd expect the service provider to honour that. And if that wasn't done, we would have the discretion then to go and reopen the case and issue a final ombudsman decision. And the reason for that obviously would be that it would be enforceable if necessary. So that's the change to the Ombudsman's decision discretion. The final one is, because it's been a full review of the rules, we have sort of implemented and made a few changes and amendments to the rules. We've introduced a new Ombudsman slip rule, which now allows the Ombudsman to withdraw a final decision in the case of obvious error without formally withdrawing the decision. And that's, for example, if there was a transposition of a figure. So this final decision says 2,900 when it was actually meant to be 9,200. This is a rare. This would be used on a sort of very rarely, but we have had cases in the past where we've had to go through the full sort of formal withdrawing of a decision where actually it's based on something that was very minor that should have easily been rectified. So going forward, we've given ourselves the discretion to do that. Obviously, we've gone through and tidied up. We've removed references to October 2010 in our preamble and references to previous complaint handling schemes, because we've been around for like 13 years now. So whereas when the scheme rules first came into being, we had to sort of take account of what our predecessor, the Legal Complaints Service, had said. We don't need to do that anymore. And there's a change to Rule 2.8 in terms of who can complain as well, to make it clear that beneficiaries can raise complaints, because we were challenged on judicial review on this. It's always been the case that we've accepted beneficiary complaints, but we wanted to make that clear. And we've also requested that under Scheme Rule 5.4, where the service provider can raise a challenge to either to our jurisdiction or to under 5.7 reasons as to why we shouldn't be looking to complain, we've asked that they bring that at the earliest possible opportunity, because we find that otherwise it just frustrates the process and elongates the complaint to nobody's benefit. So that's just a sort of a clarification on that one. So those are the changes sort of in a nutshell. In terms of what you need to do as service providers, if you haven't already done so, change your client care letter information to include the new time limits, of course, only if you undertake direct access business. Update your complaint handling procedures, either yourselves or through the chambers, and your formal complaints responses, and ensure that your chamber's information is correct as well if the chambers are providing the final complaint responses. Just so really it's only on the time limits, really. Just make sure that when you responded to a formal complaint that the client knows that they've got a year to bring the complaint to us, and the 6 months from the final date of the final complaint response as well. So if you've got any questions about the scheme rules, we have still got channels open for you to correspond directly with us. Scheme rules inquiries, SR inquiries at legalombudsman.org.uk is set up specifically for any questions that you might have about the scheme rules. If you want any general technical advice, we've been running our technical advice line for about 18 months now. I run that. If you want, you can email me about anything you want, about specific complaints, about scheme rules issues generally, about the scheme generally, any sort of clarification, advice, guidance you would want. You can feel free to email me, and I'll get a response to you within 5 working days. So those are open to you. These slides will be shared with you after the presentation tonight, so you'll be able to look at them again. And like I say, don't worry if anything sort of springs to mind after this, we are here for you, and we're here to answer any questions that you've got. So that's really me today. Thank you ever so much for your time. I'm going to stop sharing now. And we did say any questions in the chat. And we've got one from Andrew Parsons. Thank you, Andrew, for your questions. It's great to hear from Jason Chapman about these changes. Does Jason think that any more reforms might be made? In terms of thank you for that, Andrew. In terms of the changes that we can make ourselves, we don't intend to make any further changes for the foreseeable future. But like I say, the phase 2 is something that we are looking to make. I think that in reality will be a change to the case fee regime. We are sort of looking at sort of potentially a staged case fee, where if something resolves earlier in the process, it's cheaper for the service provider than if it goes to an ombudsman's decision. But what we're going through at the moment is we're putting a number of proposals together, and those proposals will eventually go to our board for their views and approval. Following that, it will be through a formal consultation, so you'll see that at that stage. But I think the other thing will be like a change to the Legal Service Act, which allows us, like I say, to outsource non-ombudsman ombudsman work to non-ombudsman, which the Act precludes us from doing at the moment. But like I say, at times of peak demand, we would want to do that just to ensure that the customer journey is as effective and efficient as it can be, which is to everybody's benefit. So so that's great. If you have no more questions, then that's me done. I don't know, Sarah, have you got any sort of final words that you want to sort of say?
Thank you, Jason. Just to say thank you very much. That was very informative, and I hope that everybody found it useful. You will be sent the slides and I think a feedback form as well, and we would appreciate it if you could take the time to fill that out. Thank you very much.
Thank you. Thank you for your time, everyone.